of the RWSS Water User Agreement.
Thank you, Mr Chairman. Look, I want to just run this item in two parts, and the first part will not be Stuart Webster, sorry. Getting too keen there, Stuart.
Degree of excitement there, Stuart.
I'd like to just ask Tom Skirman, our Economic Development Manager, just to give you a quick PowerPoint presentation on the essence of the Water Use Agreement. I'm aware that it was circulated to you back in August, so it may be time for a bit of a refresher, and then I will be asking Mr Webster and Ms Hibbert to come forward and present their legal review and to answer questions on that.
Thank you, and good morning, Mr Skirman, or was it Skegman I heard before? Practice your Pākehā pronunciation.
Yeah, you got it.
How do I go to the next page?
Just click the either page down or left mouse.
Good morning, Council. This presentation I've taken from an abridged, it's an abridged version of a presentation that was made to legal practitioners in May of this year. I think we had about 40 to 50 local lawyers, and they received a presentation from Bell Gully, who were the principal authors of this agreement. So I just want to give you a quick overview and set the scene. I know that you're be more interested in have more specific questions for Sainsbury Logan, but if I could just start off by saying what this agreement has tried to do is effectively establish a few commercial principles. The first one being the transparency of water charges. It's tried to strike a balance between the interests of water users and investors, and at the same time reinforce and confirm the regulatory framework with which water will be delivered and supplied and taken under the scheme. And it's also had the challenge of, it's a document that applies for a very long time. It's a 35-year agreement with an extension to another 35 years. In terms of the slide in front of you now, I'll just give you a brief overview of the structure of the agreement. But the items that I've highlighted and read there, I'm aware that these are some of the items that have been specifically raised for discussion, and so I won't cover those because I see that Sainsbury Logan's already given you some advice, and I'm sure there'll be some additional questions there, so I'm just conscious of time. I don't want to double up. The agreement is structured into three parts. There's the specific terms, which are effectively related to each individual farm. Then the bulk of the agreement applies to the general terms, which are not changed or do not vary across the agreement. And then we've just got a couple of schedules and appendices that deal with the specifics around water charges, and also provides farm maps and things like that as a reference point. So items that we capture in the specific terms, unsurprisingly, how much water does a water user want? What area are they looking to irrigate? Confirmation of any discounting arrangements which are within the available to foundation water users, and discussions around potential delivery points, which come down to the mechanics of the scheme. Where will the scheme deliver water to, and how will that work? Skipping over what was initially the conditions precedent and the conditions subsequent. Early in the agreement, it sets out confirms the water priority regime, which effectively just reinforces the fact that once this dam is constructed, There are certain calls on water. The first call on water is to environmental flows, safety flows, and HBRC flows. The second is to contracted water, and the third is to spot water. So that quite simply says that if there's if it's ever decided that there needs to be an environmental flow that will take, or a safety flow that will take place in precedence over delivery of water to water users. Some discussion, and it's noted in the Sainsbury-Logan document around the water supply protocols. These are, I think they're covered in clause 6.2 of the agreement. They have not been written. There's certainly strong reference to them throughout the water user agreement. I think clause 6.2 sets the framework for that. I think it may have been a little bit before my time, but there was some discussion as we could have had a crack at drawing these up and having them available to water users as they got the document. But it's just the nature of the matters that the water supply protocols are targeting that invariably, once the scheme's up and running and certain operational aspects are known, they're probably going to require amendment anyway. But so those are the water supply protocols. Supply provisions, look, very quickly, we talk about a supply year, an irrigation season and a non-irrigation season. That allows for maintenance to take place in the non-irrigation season, without the scheme being obliged to supply water to a water user. As well known, it's a take or pay agreement, so the water user agreement covers that and very specifically. There's demarcation around the responsibility of infrastructure, where the scheme is responsible and where the water user takes that responsibility in terms of the transmission of water, and a number of issues around that delivery point and metering and maintenance of that delivery point. And it goes without saying that the use of water cannot be used in any breach of a law, regulation or consents. And there is provision for on-farm storage, so you can use this water, provided you get the necessary consents to store water on your own farm. Agreement also covers instances where water is not supplied, where water is maybe ordered by a water user and is not supplied. There are three broad categories: delivery failure, delivery suspension, and force majeure. Delivery suspension, this is effectively if there's a number of items that fall under the category of delivery suspension, but this really effectively talks about situations such as priority may have been given to an environmental flow or a safety flow or an HBRC flow, or their delivery suspension also covers situations where we may be under a curtailment through climate. Delivery failure, on the other hand, is where the scheme makes a mistake. It may, and two examples we've considered it may supply too much spot water in the market, or it may spill too much water for electricity generation. And so in those instances, there's some relief for the water user. And obviously force majeure provisions are there. They apply to both a scheme or a scheme event or a farm event. The farm environmental management plans, these are obviously a critical part. Clearly they're going to be closely linked with the scheme or production land use consents. I'm sure Sainsbury-Logan will go into greater depth, but it's a requirement that a water user must have their FEMP in place before water will actually be delivered. But they do remain liable if they just haven't got round to it, or they're in some sort of disagreement. If water's ready to be supplied, they will be required to pay for that water, even though it mightn't be delivered until the FEMP is in place. And there's also, if they are in breach of their terms of their farm environmental management plan, the scheme does have the ability to suspend the delivery of water. And again, I think Sainsbury Logan has referred to, there is an ability that a water user agreement can ultimately be terminated. Not sure whether that's the right word, but if a water user is prevented from agreeing a farm environmental management plan on the basis that, that there's some regulatory restraint, then the water user agreement can be set aside. I think I'm assuming at a commercial basis that some high-level assessment is going to be taken of the likelihood of that happening, I suppose prior to financial close. The reason this clause is in there, I suppose, is because at the time the consenting regime wasn't known, so we had to leave some room for water users.
So, Mr. Skerman, I suggest now we get the Sainsbury Logan team up and perhaps have the questions at the end. Unless there's something particularly that you feel that he is not of a legal nature that he
It's
could answer.
not of a legal nature. I'd just like to come back to that FEMP. If for some reason, my understanding is probably that some reasons are fairly plain. The FEMPs are going to be drawn up by suitably qualified and independent people. Is that correct?
Look, I'm not super familiar with what the process is
Perhaps
around
we'll
it.
ask HBRC that this later when they come, but my
can
understanding is that an FEMP cannot be drawn up by anyone.
I can talk you through the process. I mean, within 12 months of financial close, a water user has to submit a draft farm environmental management plan to HBRC or whoever is the scheme owner at that stage for review, and so that gives another, effectively another 2 years to negotiate that and agree that.
And that FEMP may, under certain farm practices, not be able to meet the requirements of the consent for LUC limitations.
Well,
That would be the art on the FEMP.
That's correct. If there's a regulatory restraint,
Yeah.
there are, again, I'm probably dipping into Stuart's area a little bit, there are a number of riders on that. It's certain hurdles you've got to cross.
So it really is fairly clear hurdles. It's not just, well, you've changed your mind, you write a plan to suit it.
How that, I suppose I'll just reiterate my earlier comment, is that I think probably once the consenting regime is known and clear, I think it's my expectation that there'll be an assessment will probably be made prior to financial close as to what the likelihoods are around there.
Mr. Webster may be able to address it later after his thing. Otherwise, it's something we could take up with HBRC during their report.
Okay.
Thank you, Mr. Chairman. So the second part of the paper is obviously the discussion on the legal opinion that's been provided by Sainsbury, Logan and Williams, and Mr. Webster and Ms. Hibbert are here to present that and obviously to answer questions that may arise from that.
Thank you. Good morning, Council. I have with me Lauren Hibbert, one of my partners who co-authored the review letter that forms part of the agenda papers.
Good morning, everyone.
Just wanted to give a brief background before we go into the question side of things. And thank you, Tom, for the background. He used to be one of ours, and he did admirably well. Like the concession deed and the project agreement, there are no showstoppers in and amongst the content of the water users agreement. We might take issue with the clarity and comprehensibility of some of the clauses, for example, around deep water, converted deep water, and contracted water, but these are only semantic arguments easily fixed by a proper backgrounding. We considered that the full gambit of issues surrounding supply and delivery had been comprehensively covered off in the agreement, In particular, we looked at the issue of security and enforcement and came to the view that the credit support provisions were considerably better than a traditional principal and guarantor arrangement. We were supported in our view by the endorsement received from the banks as to the commercial viability of this type of arrangement. The ability for water users to exit the scheme is significantly constrained, so that once signed up, there are limited circumstances in which the water user can validly terminate. So in summary, the water user agreement is a comprehensive and commercially workable contract on which HBRC and HBRC and consequently HBRC can rely. So, Mr. Chairman, I'm happy to answer any questions councillors may have.
Right, any questions? Who's going to kick us off? Councillor Belford.
Good morning, sir. How are you?
Good morning. I'm well, thank you.
How's the weather in Los Angeles?
Haven't checked this morning. It was wet a few days ago. It's unusual.
If I have a number of questions which pretty much all relate to the same focal point of the security of these agreements from an environmental standpoint. I think others might have questions about the financial security of them, but before that, there is a reference in your letter to the fact that HBRC, there's a 60 million cube condition precedent mentioned that HBRC in its absolute discretion can relax. Is what you, so does that, and we've been hearing the term 40 million cubes, et cetera, but is there any actual limitation on what HBRC can recommend to us ultimately as the minimum threshold that would establish the condition precedent for initiating all this?
No, I think that's totally in the discretion of HBRC, but of course they're not going to do that if it's not financially viable, so they wouldn't be making a recommendation to HBRC for anything less than what is required to make the scheme viable. So if you look at the Foundation Water User Agreement with those initial terms in it, there is a threshold of 60 million cubes set out in writing, which of course is a safety net for HBRC, because if they don't reach the 60 million cubes, then they can validly terminate the agreement and no water user can say, I'm sorry, we have a valid and binding agreement.
So it would be a more apt question for HBRC as to why 60 becomes 40 in the normal discussion of what makes for viability.
There's no doubt in the documentation it's 60 million cubes, and that's probably a safety margin.
Right. If we go to the
Sorry.
If I may, I think the 60 million is the deferred indexation clause. My understanding, and I'll stand to be corrected, is that the 60 million is there is that if we reach 60 million, then the indexation on water price will start at the point of water delivery. That's what the 60 million is there for. It's and if we don't reach 60 million, then I think HBRC has an option there, Stuart, to as to whether it indexation starts at financial close or at the water supply, at the point of delivery. So it's really an issue around when does the price indexation start, and the financials say that the financial modelling, my understanding is that at 60 million, water up front, it's easier to have that indexation start later.
So can I just ask another question, because it talks about it talks about must satisfy by financial close. Now, financial close, as I understand it, is 30th of March next year. Is financial close in this something different? Because nobody's talking about 60 million cubes by financial close next year.
I'm not sure financial close means 31st of March next year. It's got a specific definition in the concession deed, I think, and it's taken from that. But I just need to check what the what the definition section says in the water user agreement about that, but I think it feeds back into the concession deed.
So if I could come back then to the FEMPS. First of all, is it correct that it's HBRC that is, or I think you said it's delegee, which could be a company like the port is going to be set up to run the scheme, that actually enters the agreement, that accepts the FEMP, signs off on the FEMP, is the signer, I guess, if you will, signer offer of the FEMP? Is that?
What the agreement says is that HBRC is the party responsible for entering into the FEMP and being satisfied that it adequately covers off matters including regulatory compliance and so on.
So this goes back to Christine's original questions. I mean, what it appears here is that HBRC, who has a mission of ensuring its revenue, its goals are being met from this project, is also the arbiter of whether the FEMPs are suitable to meeting the conditions that Plan Change 6, as ultimately it arrives, sets, as the ground rules for all this. So HBRC is sort of in a dual position here of wanting to have as many of these agreements signed as possible, but also protecting us that they are in fact
Poacher
of the
gamekeeper.
quality they ought to be.
Like, I think there is a way in which HBRC can be brought into line, which is the RWS consents themselves. So the regulatory authority out there can say HBRC is in breach if it's not entering into FEMPs that reflect what the regulatory regime is at a given time. And of course, we've just had the High Court case come back and the board's got some more work to do. So it's not known yet what constraints will be there, but certainly HBRC must comply with those consents, otherwise it's in breach.
But you in your report, you make clear that there is this whole reasonableness issue around which people could conceivably disagree what constitutes a reasonable agreement, what constitutes a reasonable effort on both parties to enter an agreement, all of that. That judgment of reasonableness at the end of the day is being made by whom?
That's made by HBRC, but informed by the regulatory regime and the consents that apply at the given time.
But if I am a farmer who's involved in this discussion, I can decide on Wednesday morning, enough. I've done my bit. I'm not prepared to go any further. I'm out of here.
No, that water user would be in breach then of the FEMP. They've signed up pay or take, and HBRC would be entitled then to enforce its rights under the water user agreement against that water user. That's my understanding of it.
So, assuming we're all happy now and they're all signed up, 3-4 years down the road, people are looking at these agreements. I think they have to be reviewed in some periodic basis, as does our ability to comply with the plan change. So when we get down to that point, if members of the community, let's say, believe that these FEMPs were not, in fact, achieving the conditions set forth under the law, under the regulations, could they challenge these under the RMA? Are these challengeable at some point could Fish and Game come in and say, we've been watching this process for 3 or 4 years now. We don't believe these conditions are being achieved through the FEMPs. We're going to lodge a complaint of some sort, a legal challenge to them. Is that within the prerogative of some third party?
That's an RMA question, and there will be a regulatory authority that can enforce the consents themselves. It would ordinarily be, I think, HBRC, because it's within HBRC.
In the first instance,
in the
one
first
would
instance.
hope that it would be, but if not,
Well,
You
Matt
all
and
are RMA lawyers as well. I mean, if,
I'm not personally. We could have brought a team of 20 here if we wanted to. So I'm going to defer to greater knowledge on that particular issue, and maybe the Chief Executive could answer that. But can I also say in the provisions there is a dispute resolution clause. So before you get anywhere near a standoff with these water users and HBRC, you've got the ability to go off to arbitration, well, mediation followed by arbitration. And it would, I think, be in the interests of all parties to make sure that process was successful before people got too
I understand that as it
far
relates,
down the track.
I understand that as it relates to farmers engaging in the process, but there are third parties who have strong views about protecting the quality of the river. And our own staff has advised us they believe it's going to be extremely difficult to achieve that outcome. So it's not inconceivable that a handful of years down the road here, litigious parties in the community would decide, this isn't working. We're going to go at it, and the way we're going to go at it is saying the tools that have been provided here, these FEMPs, are not getting the job done. Is that a plausible scenario?
Well, I'd imagine that would be dealt with under the EPA process, and maybe the Minister of Environment would be involved as well.
Perhaps I could try and answer that. That is a plausible process for any litigious third party, I'm sure, but there would be a high degree of evidence required to actually pinpoint what it is that is not meeting, what is making the contribution to not meeting the water quality standard. So Council, HBRC, through its State of the Environment monitoring, will be monitoring the water quality, and we will be obviously trying to rationalise, the various contributions of various causes to the standards, or to any potential breach of the standards. But for someone to actually lodge a complaint and direct it straight back to one tool out of a number would require, I think, a high level of evidence for that to succeed.
One more question?
One more, and then we'll spread it around a bit. Yeah.
On page 20 of our document, which is 14.5 of your letter,
Sure, I'm with you.
there's a discussion under that little, I'm not sure, it's 14.5, little number 2.
Yep, Roman 2.
And before that, there's a discussion of curtailment to preserve safety, environment, and so forth. As you probably know, there was some contention about in fact, about the ability of the dam to provide water when it would actually be needed. What I'm reading here is that if under all these stipulations that you note here, if the dam scheme is unable to do that for a certain number of days, et cetera, then things get triggered. The farmer is not liable to pay for the contracted water and so forth. But is there a point at which farmers could challenge? Again, we're not seeing, the water is not available when we need it. The agreements are basically not being met because, fine, 365 days, you can, in theory, any one of those days you can supply the water and tick the box and say we've met our obligation. If you're HBRC, doesn't help me if I'm not getting the water when I need the water. So this seems to be saying that the farmer has no rights of challenging, I guess, the original proposition. This is in a way an insurance policy. We were told we would get water when we needed water. That's not happening. We think, is there a grounds of challenging the structure of this at that point?
Simple
Seems to be a buyer beware situation here in the extreme.
Simple answer is no. No way of challenging it, and there are a couple of parts in there. First is that the agreement specifically refers to the Contractual Remedies Act, which is to do with misrepresentations, so that the HBRC can't be liable for any misrepresentations about its honest belief to deliver water in such quantities as might be required by those water users. And then, of course, there's been a due diligence period available for both water users and for HBRC and the council to look at the feasibility of the scheme, not just from a monetary point of view, but in fact delivery of water. So if you get down the track and there's a failure for 365 days continuously, the water user can terminate, and there is no right of comeback by the water user against HBRC or anyone else.
Okay.
Thank you. Other questions? Who else have we got? Councillor Graham.
I have two questions, Chair.